I mean, to our speaker's cousin, who is Joe Sherman. Take it away, Joe.
All right. Well, Steve has a fantastic resume, which you could all read about if you haven't seen it. It's on the American Civil or New York Civil Liberties Union website. And
ACLU website.
The ACLU website, and you could Google him and all that. But I don't think it'll tell you that he grew up in Jackson Heights, Queens, and there are 4 sisters that include my mother and his mother, and then the mother of 2 other cousins, and then the unmarried sister. We all grew up in the same co-op between 32nd Avenue and Northern Boulevard in Jackson Heights, Queens in the 1950s. And Steve went on from there to attend Bronx High School of Science, Columbia University, and Harvard Law School, and the rest is history. So he worked extensively preparing cases for the Supreme Court, for the American Civil Liberties Union. And so he knows wherever he speaks, he knows that court very well. He could tell us about his experiences in it and how it works and what he thinks the state of it is right now. So Steve, take it away.
All right. Thank you, Joe. So let me just add to what Joe said, that for 23 years, from 1993 until 2016, when I retired, I was the National Legal Director of the ACLU, which is to say I was in charge of the ACLU's legal program nationwide. And part of my responsibility included supervising the ACLU's work in the United States Supreme Court. The ACLU is a very active player in the Supreme Court because they decide a lot of issues and cases that we care about. And so over the span of that nearly quarter century, I participated in well over 200 cases in the United States Supreme Court, including several that I argued on my own. So, and since I stepped down from that position in 2016, I have been teaching a course on current issues in civil liberties and civil rights at both Columbia Law School and NYU Law School. So I have a long history with the Supreme Court, but it's processed through a certain filter, and that filter is my work at the ACLU. So let me begin with some preliminary comments, and then I do want to leave time for question and answer because I want to be sure that I can respond to whatever questions and concerns you might have. And I also am not sure how much background knowledge you may have about the Supreme Court and how it functions, and that background may not be consistent across the group. So I'm going to begin with some things that may be well known to some and perhaps not to others, and then move on from there. Let me just start off by saying that progressives have every reason to be very worried about the Supreme Court and the direction in which it is heading. This is the most conservative Supreme Court that we have had probably since the 1930s. Having said that, it's also important to note that the Supreme Court that many of us think about when we imagine what the Supreme Court should be and how it should be behaving is the Warren Court of the 50s and 60s. But the Warren Court of the 50s and 60s is an anomaly in American history. For much more of our history, the Supreme Court has been an impediment to social justice. It hasn't been a catalyst to social justice. And the only period of time in which that really was not the case was that period of time from the early 1950s to the mid or late 1960s. To make perhaps an obvious comment, but an important one, we do not live in a pure democracy in the United States. We live in a constitutional democracy, and the central paradox of that constitutional democracy is why we entrust 9 unelected judges with the authority to overrule the decisions of elected political officials in Congress and in state legislatures. that is true in some other countries in the world, but not true in many. And the traditional explanation for handing that power over to our judges and to the Supreme Court in particular is that it enables the court to protect the rights of minorities who are underrepresented or marginalized in the political process. And in periods of time when the court is not performing that function, does not appear to be protecting the rights of marginalized communities, but if anything, actively suppressing those rights, questions about the legitimacy of the Supreme Court and its role in our democracy become more acute, and that is the situation in which we now find ourselves. The Supreme Court is the only court that is specifically mentioned in the United States Constitution. Article 1 of the Constitution sets forth the powers of Congress. Article 2 sets forth the powers of the presidency. It's important to note that Congress came first, the presidency came second in the Constitution. And the power of the judicial branch is set forth in Article 3 of the Constitution. And all Article 3 of the Constitution says is that it establishes a Supreme Court and such inferior courts as Congress shall choose to adopt. So Congress could have created a Supreme Court and nothing more. We now have a more elaborate federal judicial system with 3 layers of courts. There's a trial court. There are 12 regional appeals courts, and then there is, as the third and final arbiter of our rights, the United States Supreme Court. It's also important to note that the power that we now take for granted, the power of the Supreme Court to declare acts of Congress or acts of state legislatures, or in fact, indeed acts of government officials of any kind and any level, to declare those acts unconstitutional is not a power that is specifically granted to the court in the Constitution. It is a power that the Supreme Court claimed for itself, and claimed for itself 16 years after the Supreme Court, after the Constitution was written and ratified in 1787 in an 1803 case called Marbury versus Madison. Written by what most people consider the great Chief Justice in American history, John Marshall, who was both a cousin and a political enemy of Thomas Jefferson, who was the president at the time. And in Marbury versus Madison, John Marshall said it is indisputably the province of the judiciary to declare what the law is, and if elected or public officials, of other administrative officials, act in a manner that is inconsistent with what the Supreme Court declares the law to be, then those acts are null and void. The Supreme Court has the power to overrule them. For more than half of our history, maybe just about half of our history at this point, the Supreme Court rarely exercised that power on behalf of minorities or to enforce political rights. The concept that we all now have, that if the government acts in a way that we think violates our rights, we can go to court, and if the courts agree, the courts will declare the government's actions unconstitutional and either stop them or order them to pay damages to the person whose rights have been violated. That is very much a concept of the 20th century. It's not a concept that was present throughout American history. And to the degree that the Supreme Court was in the business of declaring rights in the 19th century, it was primarily to protect the property rights and business rights of the propertied and business class, with the most notorious case being the Supreme Court's decision in 1857 in Dred Scott, declaring that enslaved African Americans were not citizens. To the contrary, they were the property of their slave owners and had to be returned if they escaped into a free northern state. It is often surprising to people when we think about the Constitution. and think about the Bill of Rights. The Bill of Rights was not part of the original Constitution, as you probably all know. The Constitution was written in 1787. The Bill of Rights, first 10 amendments were adopted 4 years later in 1791. But when we think of the Constitution, most people normally frequently start with the First Amendment, which protects freedom of speech and freedom of the press and the right to assemble, and requires a separation of church and state. And we are now used to the Supreme Court deciding important free speech cases, but the Supreme Court did not decide its first free speech case until 1919, which was 128 years after the First Amendment was adopted. So we went 128 years in our history without a single decision from the United States Supreme Court, even explaining what it thought the right to free speech means, let alone trying to enforce those rights. And the first decisions in 1917 interpreting the First Amendment arose out of political dissent during World War I, and those decisions were all decided in favor of the government and against the rights of the protesters. And it took another decade before the Supreme Court, for the first time, declared a state law to be unconstitutional under the First Amendment. Likewise, we take it for granted now that the government should not at least expressly discriminate on the basis of race. And if it does so, it needs a very, very good reason to explain what it is doing. But the first case in which the Supreme Court ever announced that racial classifications were inherently suspect, in the language of the constitutional law, inherently suspect, and can only be justified by the most compelling of governmental interests. The first case to announce that principle was a case called Korematsu versus the United States, which was the internment of the Japanese Americans during World War II. And after declaring that racial classifications by the government were inherently suspect, the court went on to uphold the internment of the Japanese Americans because it was World War II, and it thought the government's national security interests overrode the right to racial equity and racial justice. The other thing that is not mentioned in the Constitution is the size of the Supreme Court. The Supreme Court has been composed of 9 members, certainly for all of our lifetimes, but in fact since 1869, but it was not always so. The original Supreme Court, the first Supreme Court in 1788, had 6 members. That turned out not to work very well. Even numbers tend not to work because you get ties. And so the 6 members were increased to 7. It then went up to 9. At one point, it was as high as 10, dropped back to 7, and then became 9 again for the final time in 1869. And that's where it has been ever since. And we can get to the size of the Supreme Court when we talk a little bit about current proposals to reform the Supreme Court. Let me talk a little bit about kind of what's before the Supreme Court at the moment. And I think the biggest impact on our political life over the next couple of years is not going to be a result of any decision that the Supreme Court announces this year. The Supreme Court term goes from October to June. It's not going to be a result of any decision announced this June. It's going to be a result of a series of decisions that the Supreme Court has announced over the last couple of years, and that is because we are about to enter a phase of political redistricting around the country where not only congressional lines, but state legislative lines around the country are going to be redrawn. And under the Constitution, the power to redraw those lines rests with state legislatures, and the state legislatures have gotten very good, both parties have gotten very good at engaging in a practice known as partisan gerrymandering, which is to say drawing the lines in a way that favor the political power of whatever party is in control of the legislature when the lines are being drawn. And several years ago, 2 or 3 years ago, the Supreme Court announced that federal courts had no role in reviewing partisan gerrymandering. I can get into the reasons why they said that. They said that partisan gerrymandering, at least when taken to an extreme, was anti-democratic. But it was an anti-democratic process for which there is no longer any possibility of a remedy in the federal courts. And so that has unleashed the state legislatures, who don't even now have to fear a possible adverse federal court ruling, to engage in the most extreme partisan gerrymandering that their computer models are able to devise. That's a real problem, and we're going to see that play out over the next 12 months. The other form of gerrymandering that is related but separate is racial gerrymandering. Racial gerrymandering is drawing district lines in a way that suppress the political powers of racial minorities. Both parties engage in partisan gerrymandering if they can. Racial gerrymandering tends to be the sole province of the Republican Party, and it's not because the Democratic Party is saints on these issues. It's just because the Democratic Party believes that generally enhancing the political power of racial minorities enhances the political power of the Democratic Party. So it is to their political advantage to maximize minority voting strength, and the Republicans have drawn the opposite conclusion. And so the Republicans engage not only in partisan gerrymandering, but racial gerrymandering whenever possible. Racial gerrymandering.
Here, come up.
Racial gerrymandering is also illegal under the law, but as a result of a couple of Supreme Court decisions over the last 6 or 7 years, and again, if anybody's sort of interested in the nitty-gritty details, I can explain how the court got to this place. But racial gerrymandering cases have become much, much, much harder to win as a result of principally 2 decisions by the Roberts Supreme Court. So we are in a world now where we're about to embark on political gerrymandering with very few legal constraints to safeguard against either partisan overreach or racial inequality. And, we will see the results of that, as I said, relatively shortly. So that's a series of political events that are going to play out over the next 12 months against the backdrop of Supreme Court decisions, for the last 5 or 6 years. The Supreme Court now is facing at least 3 big issues that it will decide this term. None of which I think we ought to be particularly optimistic about. The first is abortion. There's been a lot in the news about abortion. There are 2 cases that the Supreme Court has agreed to decide. The first is a case out of Texas, and that's been much in the news, and I will assume most of you have read about it, but it prohibits all abortions in the state of Texas after 6 weeks of pregnancy, which is before many women even know that they are pregnant, and authorizes any private individual anywhere in the United States, doesn't even have to be somebody who lives in Texas, to bring a lawsuit against not only the doctor who performs the abortion, but anybody who aided and abetted the abortion, and to recover $10,000 in damages for each abortion that was performed in violation of the state law. That law is going to be argued on November 1st. So a week from Monday, a week from yesterday, it's going to be argued in the Supreme Court, but it's going to be argued on a series of procedural questions that are very important, but don't reach the ultimate question of whether Roe v. Wade should be overruled. Really deal with the question of whether the case can proceed in the lower courts or whether it should be dismissed. The question of whether Roe v. Wade should be overruled is directly before the Supreme Court in a case out of Mississippi. That case is going to be argued, I believe, on December 1st. I don't quite remember that it could be December 11th, it's December 1st or December 11th. And Mississippi is asking the Supreme Court to overrule the 1973 decision in Roe v. Wade, guaranteeing a right to abortion. Pre-viability, viability is generally understood to be after about be up to the 24th week of pregnancy. The Mississippi law prohibits all abortions after 15 weeks of pregnancy. So it is directly at odds with the principle of Roe. And I think the big question on everybody's mind, there are 6 people on the Supreme Court now who are opponents of Roe v. Wade. The only question is whether they will use this opportunity to overrule Roe v. Wade completely, which would mean there was no longer a constitutional right to have an abortion in the United States, and the right to have an abortion would entirely be a function of state law. So if you lived in a state that allowed those abortions, you could have them. If you lived in a state that didn't, you couldn't at home. You would have to travel in a state that did allow them. So there are 6 people on that court who I think would like to see Roe v. Wade go away. The question is whether this becomes the case in which they do it, or if they find some narrower way, which is what they've been doing over the years, to chip away and chip away and chip away at the right without directly overruling Roe itself. It is thought that there are maybe 1 or 2 people on that court who are hesitant, while they do not like or agree with Roe v. Wade, may be hesitant to overrule it, including the Chief Justice, John Roberts, because they're worried about its impact on the reputation of the court. So they'd rather maintain Roe and turn it into an empty shell than expressly overrule it. But, you know, I used to think that that was the likely outcome. I'm now not so sure. I think Roe is hanging on by a thread, but we will know what the answer to that question is sometime in the spring of this year. The court also has a gun rights case, a Second Amendment case before it this year that it is going to decide. The Supreme Court, I don't know, 15 or 20 years ago, overruled what had been almost a century of prior law to declare the Second Amendment protected an individual right to possess weapons, at least in your home, and has not decided a Second Amendment case since. Well, now they have another one before them, and this is a case out of New York. New York has a law that prohibits people from carrying handguns outside their home for purposes of self-defense, and that has been challenged by gun owners who think they have a right to defend themselves outside their home as well as inside their home. And the absolute prohibition in New York law therefore violates the Second Amendment. They've brought that case to the Supreme Court. I'm nervous about what the Supreme Court will say about that one as well. And then the Supreme Court has not yet taken, but I think is likely to take, an important affirmative action case involving the admissions policies at Harvard University, the affirmative action plan at Harvard University, and whether in essence it represents a form of reverse discrimination, although the twist in this case is that the reverse discrimination claim is not being made on behalf of white students, it's being made on behalf of Asian Americans who claim they are subject to a cap, a quota system at Harvard in order to enable Harvard to bring in more African Americans and Latinos into the incoming class. This is, again, a court that has no great sympathy for affirmative action. I think the chances are decent that it will say that Harvard acted illegally in the way it chose to admit students. And as in the abortion case, it has 2 options open to them if that's the course they want to take. One is just to say Harvard didn't follow our rules. The other is the more extreme course to say that affirmative action is never constitutional in any circumstances, no matter how you do it. And we made a mistake when we said to the contrary a few years ago. So we have the redistricting brouhaha that's going to play out. We have the huge spotlight shining on abortion. We have the gun rights case. We have affirmative action. You know, there may well be other things that come up before the court, and we have a solid 6-3 conservative majority, and the oldest person on the court, as you all know, is Justice Breyer. And if he doesn't step down soon, and it would be truly unusual for him to step down in the middle of a term unless health compelled him to do so. So if he waits until next summer, it's anybody's guess of whether the Biden administration will be able to get a Democratic nominee. So we could be facing a 7-2 court, but even a 6-3 court is a very difficult court to litigate in if you are a progressive advocate. So increasingly, what you see among progressive social justice advocates is a shift in strategy away from the courts. The instinct of my generation was always to sue over everything in the hope that the Supreme Court would provide the right answer. Now people are increasingly looking for ways to achieve social change, really from the ground up as opposed to the top down, by engaging in community organizing and political organizing. And so it has shifted in many ways the focus of political advocacy in the country in a way that in the long run may be healthier. But as somebody who spent his career litigating and working with the Supreme Court, it was nice to think that you had some allies there who could backstop you if the political system failed, as it so often did. If you don't feel like you have the Supreme Court at your back, then you've lost one very important tool for achieving social change. So that's where we are now in a very quick thumbnail. And well, let me just say two other things, and then we can open it up for discussion. After Mitch McConnell in the Senate stonewalled Merrick Garland's nomination, which ultimately got us Brett Kavanaugh in the Supreme Court. And then after he rushed through Amy Coney Barrett's nomination after the death of Ruth Bader Ginsburg, there was a real backlash about the Supreme Court nomination process and about the Supreme Court itself. And the Supreme Court's polling numbers, to the extent that they pay attention or care, and they do, even though they will never admit that, but their polling numbers have been going down dramatically. They are still much more trusted than either the executive branch or or Congress, but that's a pretty low bar. By Supreme Court standards, their role in society is being increasingly questioned these days. That led Joe Biden, as you probably know, to appoint a commission to examine various ways in which the Supreme Court might be reformed. Some of them are small, some of them are big. The two that are biggest are the proposal to impose an 18-year term, one term only for 18 years on each Supreme Court justice. The current rule is Supreme Court justices serve for life, and that has led to more and more extended terms as people are being appointed at an earlier age and living to later in life. So it's no longer uncommon for Supreme Court justices to serve for 30 or 40 years. So one proposal is to eliminate life tenure and create an 18-year single term instead. The other possibility, the other big reform proposal that you hear people talking about is to increase the size of the Supreme Court to try to counterbalance the conservative tilt while the Democrats are still in control of both the White House and the Congress. My own feeling about it, just to get it out on the table, is I actually am a supporter of the 18-year term, and they would be staggered in a way so that every 2 years there'd be a new vacancy on the Supreme Court. So every president who served a 4-year term would be guaranteed 2 nominations. And the thought is that would sort of dull the partisanship because everybody knew they had a turn coming. I'm a fan of the 18-year term, but I don't think it can be done by Congress. I think it has to be accomplished by constitutional amendment, and then that is very, very, very unlikely to happen. And I say that because the provision for life tenure is written into the Constitution itself. So if you're going to change it, you have to change the Constitution, in my opinion, at least. You don't need a constitutional amendment to change the number of justices on the Supreme Court. As I said at the beginning, that's been done in the past. Sometimes successfully, and most notoriously maybe when FDR threatened to pack the court in the 1930s and then ultimately backed down and didn't do it. And so Congress could tomorrow, if it wanted to, increase the number of justices to any number it wanted. There's no maximum. It could, if it wanted to give the Democrats a majority and they're down 6-3, it would have to add 4 more seats to the Supreme Court. So that would take it from a court of 9 to a court of 13. And then, if the politics were right, you could wind up with 7 Democrats and 6 Republicans. I don't happen to be a fan of that as much as I am concerned and worried about the current Supreme Court, because it just seems to me we'd be in an endless loop depending upon who was control, and the size of the court would go up and down, and nobody would ultimately benefit. Everybody would play the game, and the court would lose the dwindling legitimacy it still has in the eyes of the American public. The other thing I wanted to say is we are witnessing a period, and we talk about the Supreme Court. I just talked about the Supreme Court by saying 6 Republicans, 3 Democrats. That didn't used to be the way that we referred to judges in general or Supreme Court justices in particular, but the Supreme Court has become polarized in a way that the rest of the society has become polarized along partisan lines. And it is true that there are differences among the 6 Republicans, just as there are differences among the 3 Democrats. And there are occasions when John Roberts and others in the conservative wing may wind up allying with the liberal wing in a particular particular case. But over the span of time, those political affiliations are reasonably good predictors of how the Supreme Court is going to decide the kind of big social cultural issues that I've been talking about. It's different when you get a very technical case about how, a pension law that Congress has written that nobody understands should be properly interpreted. That doesn't tend to cleave along partisan divides. But when you're talking about abortion, or you're talking about the Second Amendment, or you're talking about voting rights, then the partisan divide becomes much more predictive. And that's not because the justices go back into their office after hearing a case and think to themselves the way Mitch McConnell or Chuck Schumer might, which is to say, what's good for the Republican Party, what's good for the Democratic Party. I don't think that's the question they ask themselves. But they have a certain worldview, and that worldview aligns with their political affiliation. And that worldview also influences the way they see and interpret the Constitution, because there are different plausible methods of interpreting the Constitution. And if you have a conservative worldview, you interpret it in one way. And if you have a more progressive worldview, you interpret it in a different way. And that leads to politically polarized results without having to ever be expressly partisan. So when Amy Coney Barrett delivers a speech, as she did the other day, and said, "We are not partisan hacks," they're not partisan hacks in that same way, but they are increasingly behaving in partisan fashion, and that's a problem. That's a problem, to get back to the first question I posed. If you want to spend any time thinking about why we give them the power to overrule other partisan branches of government if they are going to behave in a partisan way themselves, then why isn't it just the majority rules? So that's where we are. And Gene, maybe we can I'll stop there and we can open it up for questions.
George, if you can unmute and take charge of who's going to be speaking, in which order.
Well, good evening, everyone. Well, right now I don't see any questions in the box except mine, actually. So
Okay.
if anybody has any other questions, please enter them in. Otherwise, I'm going to start with the question I put in the box. So I'm going to start with
George, start with you.
So, okay. So I asked, how would increasing the number of Supreme Court justices change the outcome of decisions in the court? and how people view the Supreme Court in both the short term and long term?
Well, it would alter the outcome if you could ideologically pack the court with people who shared your own political philosophy. So in the case of the Democrats who are outnumbered now, if you could add four more Democrats to the court, four more liberal Democrats to the court, you would wind up with 7 Democrats and 6 Republicans, or several constitutional liberals and 6 constitutional conservatives, however you want to label them. And that would lead to very different results. It would have led to a very different result in the redistricting cases. It would lead to a very different result in the abortion cases. It would lead to a different result on affirmative action and on the Second Amendment. All those cases would come out differently if there was a majority of liberals / Democrats on the Supreme Court. But I think in the long run, it would be a temporary empiric victory, because it would last only until the Republicans got control of the political machinery, and then they would use the same power to transform the court again. And I think once you start to do that, certainly more than once, but maybe even once, the Supreme Court would lose a lot of legitimacy in the eyes of the American public, because it would no longer seem like something other than another political branch of the government. And that's not the way the court perceives itself, and that's not the way the court wants to be perceived. Because as many years ago, Andrew Jackson responded to a decision from the Supreme Court he did not like by saying, the court has made its decision, now let them enforce it. They have no army, they have no power of the purse. Even their unpopular decisions are by and large respected by the American public and uniformly followed by the political branches. But that all depends upon a shared understanding that they are engaged in a different exercise than elected political officials. And if people start to think that's no longer the case, then another sort of one of the 3 legs of our 3-legged democratic stool becomes seriously destabilized.
Okay, Jackie asks, would it be worthwhile and viable to proceed to concur, increase the number of judges, and start the process of limited tenure?
Yeah, it's a possibility. I don't. It's a theoretical possibility. I don't think at the moment it's a political possibility. In order to have a constitutional amendment, you need 2/3 of both houses of Congress to agree and 3/4 of the state legislatures to agree. So if you just sort of think about the political landscape at the moment, you realize what a difficult enterprise that is on an issue that is as politically charged as this one. And so, my worry about packing the court, as it were, is that as a transition to shorter terms, is that we would never wind up with the shorter terms, and we would be left with a packed court that was only, to our advantage, however you define our advantage, until the other side was in control and packed it in their advantage. So I think the 2-stage strategy is not a bad one. It just doesn't seem to me a realistic one.
Okay, so Joe Sherman asks, is there any place for precedence in the decisions of the Supreme Court?
Yes. The Supreme Court pays lip service to precedent in order to, it's more than lip service. The principle that issues once decided should remain decided unless there's a very good reason to change the court's view. But there are now at least two members of the Supreme Court, Clarence Thomas and Neil Gorsuch, who seem not to care about precedent at all, which is a very sort of unusual position for a sitting judge to take. Their position, which has certain common sense appeal, I would suspect, to many people, is if we got it wrong, why don't we just admit we got it wrong and fix it? Where others would say it's not enough that we got the prior decision wrong, it has to have been really wrong, because we want people to believe that there is laws more than the sort of personal whims of the 9 people who are sitting on the Supreme Court at any time. There's a continuity that moves on from court to court. The difficulty, Joe, is this. Again, when we're talking about the kinds of issues that I worked on, the kinds of issues that you really care about, which is everybody would say precedent is important, but everybody would say that there are certain mistakes that just need to be corrected, right? And so the example that everybody always gives is Brown versus Board of Education. And Brown versus Board of Education in 1954 overruled a case from 1996 called Plessy versus Ferguson, in which the Supreme Court had said there's no violation of equal protection as long as the state provides separate but equal facilities, right? Because separate but equal facilities are equal, and that's all the Constitution guarantees you. And then in 1954, in Brown versus Board of Education, Earl Warren said separate educational facilities are inherently unequal, and the court was wrong when it said the opposite in Brown versus Board of Education. And in Obergefell versus Hodges, when the Supreme Court just recently said there was a constitutional right in favor of same-sex marriage, it reached that decision by overruling a prior case in which it had said the opposite, as it did when it said consensual sodomy laws are unconstitutional, overruled a case from only about 15 years earlier, where it said the states could make sodomy a crime, which is to say make homosexual sex a crime, if that's what they choose to do. And so the difficulty you get in when you start arguing about the value of precedent and precedent is stabilizing, and one thing that distinguishes judges from politicians is politicians can change their mind on a dime, and judges have to worry about what prior courts have said. If you have this conversation with a conservative, they're going to say, you didn't say that in Brown, you didn't say that for same-sex marriage, and you didn't say that for consensual sodomy. So why should we say that for Roe v. Wade if we believe that abortion was murder and the court made a terrible, grievous mistake when it decided Roe v. Wade? It becomes a hard argument because it's never an absolute principle.
Okay, Gene has a question. It says, it seems the court is fast losing legitimacy. What's your prediction of what will happen?
I don't have a silver ball to that, and I think that I don't know. It's a very good question. I don't know the answer to that, because it is losing legitimacy, and it's part of a generalized loss of faith in government institutions across the board, right? People just don't have much faith in the government to operate in their interests at this stage. And, I don't know how the court gets out of that spiral, and I don't know how Congress gets out of that spiral, and I don't know how the presidency gets out of that problem. But I think we are really facing a serious democratic crisis here, because democracy ultimately relies on a leap of faith, and if you lose that faith, then the democracy starts to crumble. Now, some of this is cyclical. I mean, the Supreme Court in particular has gone through some very unpopular periods in the past, and and it has recovered. People thought after Bush v. Gore in 2001, the legitimacy of the Supreme Court would never recover, and that turned out not to be the case. If you believe that poll numbers actually tell you what people think about the Supreme Court, and I do think people, it's still, there's a residue of belief. I have a residue of belief that says they may be political, but they're a different kind of political, and it's still an important institution to maintain, even as we try to influence it and change it. And my worry about the court packing or adding members to the court is that it will accelerate the delegitimizing process rather than halt the delegitimizing process. But I guess time will tell.
Okay. No, Lee Chong says, under what circumstances could Citizen United be overturned? Is it likely or is it a pipe dream?
It's a pipe dream as long as the composition of the court remains as it is. And the thing to know about the 6 conservatives on the Supreme Court, all of whom support Citizens. I mean, if Citizens United were before the Supreme Court now, the vote would be 6-3 in favor of what was originally a 5-4 decision. And with the exception of Clarence Thomas, who's in his 70s, the other 5 members of that conservative majority are all quite young, and you can reasonably expect, except for some unforeseen, illness or incident, that they will remain on the court for the next 20 years, and they have no interest in overturning Citizens United, which means that Citizens United could then only be overturned by a constitutional amendment because it was a constitutional decision based on the free speech clause of the First Amendment. And we just don't amend our Constitution very often. One of the things about the Constitution of the United States is there are several things to be said about the Constitution of the United States. It contained many fundamental flaws at the founding that we all know about, including the acknowledgement and acquiescence in slavery. It created these structural problems that we're now living with in the Electoral College and the equal representation in the Senate, which allow a minority of the population to control a majority of the political positions. It did not, as most post-World War II constitutions in Western Europe now do, it did not include any constitutional protection for what the law describes as social, economic, and cultural rights. It only protected civil and political rights. So there is no right to housing, there's no right to education, there's no right to a living wage there's no right to adequate medical care in the United States Constitution, whereas there is in many Western European constitutions. And it made the Constitution very hard to amend. And so we had 10 amendments right off the bat. We had another 2 pretty quickly. There were 3 after the Civil War, the 13th, 14th, and 15th Amendments. We're now up to 27. A lot of the more recent amendments have been kind of small and technical. It's a hard road to amend this Constitution.
Andrew Kaplan asks, as individuals, what might be the best actions we could take to, 1, support the 18-year term limit, and 2, influence the court's decision? I'm going to add, why is it 18? Who came up with the idea of an 18-year term limit?
I don't know where 18 came from precisely. Again, the United States is the only Western democracy that gives life tenure to its Supreme Court justices. So the Supreme Courts or the constitutional courts in other Western European countries or developed democracies all have a term of years that their highest judges serve, but it's not life tenure. Without knowing precisely why somebody chose 18 as opposed to 16 or 20, the basic idea was the advantage of life tenure is it gives judges independence. And I think that's true. They're not elected and they don't have to run for re-election or wait for reappointment, all of which can bias their decision-making in various ways when they try to curry favor with whoever controls, their ability to remain on the court. So the theory was 18 years would be long enough to give somebody a significant tenure on the court, long enough to ensure one term ensures independence because they can never run again, either for appointment or election. And yet short enough that it would allow for turnover in the court and could be staggered in a way that would ensure every president the opportunity to have 2 appointments per term. But why exactly 18? I don't have the answer to that. I think the answer it's there's no direct way I think for the citizenry to influence Supreme Court decisions. Their independence, their life tenure, puts them in a position where they don't have to really worry about whether or not people agree or disagree with what they decide or like or dislike them personally. That being said, there is this long held view, which I think is basically accurate, that the Supreme Court also doesn't like to get too far ahead of where the country is, especially on these kind of major social and cultural issues. And so if it feels the country shifting away from where the Supreme Court is, the Supreme Court adjusts, although not in a direct causal way. It's not like holding an election, but they like to be sort of part of the larger social gestalt and not entirely divorced from it. So I think the way people can influence what the Supreme Court does is the way we do most things in our democracy, and that is by participating in the political process and changing political outcomes. And if that happens, the Supreme Court kind of gets that message and adjusts accordingly. So it's an indirect influence rather than a direct influence on the court itself.
Okay. So now Lee Chong had another question. Says, is the ERA dead? I hope we know what that means, because to me,
Yes.
ERA means earned run average. And
Yeah.
I understand and considering the World Series about to start, and I understand under the current court, it will not be resurrected, but can it in the future?
The ERA, in addition to earned run average, means the Equal Rights Amendment. The Equal Rights Amendment was, in fact, passed by both houses of Congress and sent to the states for ratification. And it requires ratification by 3/4 of the state legislatures, which is 37 states. And I think, and the resolution adopting the ERA in Congress, as most recent constitutional amendments have done, gave the states 7 years to ratify. It wasn't open-ended. It said you have 7 years to ratify this. And within the 7 years, I think they got up to 35. And 35, is that right, Lee? Yeah, I think they got up to 35. Since then, a couple of the states that initially ratified it have tried to revoke their ratification, and a couple of other states have tried belatedly now to ratify it. And there is an unanswered question of whether Congress can in fact impose the 7-year limit. Is that actually binding on the states, or once you get to 37, bingo, do you have a constitutional amendment? Just as there's an open question about whether a state that has once ratified it can revoke that ratification before you get to 37. I think, again, the Supreme Court hasn't told us their answer to the question. I think the Supreme Court is going to say the 7 years is a reasonable limit and you have to do it within 7 years. It doesn't make sense to say 120 years later you can get the extra state and add an amendment to the Constitution. So my guess is the ERA, as it was passed, whenever it was passed, 30 years ago, I think that fight is probably over. If you wanted to amend the Constitution to include an ERA, I think you would have to start all over again. Having said that, however, at the time the ERA was passed, there was very little protection against sex discrimination in the Constitution itself, and due to the work of Ruth Ginsburg and others, the existing Constitution is now much more protective of sex and gender discrimination than it was at the time of the ERA. Not to say that it's not needed, but we're not quite in the same position. And the Supreme Court has now recently said that the legal protections against sex discrimination also protect gays, lesbians, and transgender individuals because discrimination against them is a form of sex discrimination. So we have sort of a more robust body of law. I don't think we're going to get the ERA back, is, again, my own personal view. Okay.
So I'm going to follow the question I put in the chat, and I was waiting because I wanted to see more people put in questions. How would term limits affect the tenures of the Supreme Court if the seat unexpectedly opens when there's already a scheduled vacancy due to term limits? For
Yeah,
example, you might
yeah,
have two seats that would have around the same, more or less the same end date.
yeah.
Following up with that, since you mentioned, for example, the 18-year term limit, if let's say Congress decides to pass this tomorrow, and it will go into effect. For example, Chief Justice Roberts has had about 16 years already. Would that mean that he'd only have about 2 years left in his term, or would it start like once that instituted? So it's his 16 years he's already been in plus 18 years.
Yeah, I think those are details that have not yet been worked out. We're still sort of flying at the 30,000-foot level, but they're all very, very good questions. And add to that list, what happens if there's, you're rotating and somebody's vacates the court and it's time for a new nomination, and Mitch McConnell simply refuses to move the nomination in the Senate. Right, says I'm not going to do it. What do you do about that? So those are all very important and practical questions. And it's not just that I don't have the answer. I think people have said if we can agree on staggered 18-year terms, if we can agree on that much, then we will sit down and start trying to work out the details. But I don't think most people have worked them out yet.
Okay, so Jackie Fisher, it's really more of a comment, but she said, if the lower courts are the pipelines to the Supreme Court, they're pretty much politically packed with Republicans by the prior administration.
Yes, but that is a place in which vacancies occur much more frequently. And Joe Biden is now appointing lower court judges at a faster rate than even Donald Trump did. And so that's a pendulum that can swing back much more quickly. There are just many more of them. So vacancies and retirements occur much more frequently than among the 9 members of the Supreme Court. The other thing about lower court, I mean, there is 2 things to be said about lower courts and just the work of lawyers and judges in particular, which is the vast majority of cases that are brought to court, whether we're talking about the federal courts or state courts, don't involve these kind of high profile, politically controversial issues. They involve much more mundane questions where the outcome doesn't really turn on the political affiliation or judicial philosophy of the judge. And often what the judges are being asked to decide is a disputed question of fact, not a disputed question of law, right? Did somebody rob the bank? Who was responsible for the car accident at the corner? Those are not cases that turn on, anybody's deeply held views of the Constitution or the relationship between judges and the political branches. So I would say both of those things are true. The lower courts are starting to shift back, although there were a lot of appointments under Trump. He had 4 years. Biden has only 1, but his pace is faster. And just remember that most cases aren't about abortion or affirmative action or capital punishment or any of those things. They're about contracts and landlord-tenant disputes and other kinds of issues.
Okay. The Joe Sherman had a comment, perhaps it's 8 years because 18 equals 9 times 2.
Yeah, it might be in order to get the 2-year sequence. That's right, Joe. It's the math teacher in you, Joe. Right. Okay.
Andrew Kaplan asked, what are some of the good places for us to keep in touch with the actions of the Supreme Court?
There are a couple of both the New York Times and the Washington Post and the Wall Street Journal and NPR, all 4 of those outlets, which, I'm sure almost all of you read at least some of them. All 4 of them have very, very good dedicated Supreme Court reporters who do a very good job of covering the court and explaining the court. The place that the real Supreme Court junkies go to, but they make a real effort to talk in layman's language, is a blog called scotusblog.com, SCOTUS, Supreme Court of the United States, SCOTUS blog.com. And they do a very good job both of previewing issues that are coming before the Supreme Court, very quickly disseminating and explaining decisions by the Supreme Court, and then aggregating, useful newspaper articles about the Supreme Court. So that's the one-stop shopping place if you want to dig deeper than what Adam Liptak or Nina Totenberg is going to tell you.
Okay, since I don't see any other questions, last question. Since it's a hot topic in the news, the issues with vaccinations is a situation where the Supreme Court could possibly have to take up a case about whether vaccine mandates are legal, and where does the court likely stand? Where does the court likely stand on there if they ever choose to take up a case such as that?
My guess would be the court is going to uphold the vaccine mandates, but the more difficult question for them is going to be religious exemptions from the mandates. So that's where I think they will have a harder time. But whether the state can impose mandates on people who just object on it's my body, I will decide what goes in it. I think the Supreme Court probably rejects those challenges. People who say they have a religious objection, I think, may get a more favorable audience in the Supreme Court. That's what we saw happening about, the closure rules that were being challenged a year ago when churches were coming in and protesting that they weren't being able to hold services, and the Supreme Court was pretty sympathetic to their concern and pretty skeptical of the state's reasons for shutting down the church services.
Okay. Is there any other
Well,
questions?
Let me just say one other thing about one other hot button issue. I used to say, and I guess two things I used to say when I was at the Supreme Court. One, people would say to me, what are the big civil liberties issues of the future? And my answer to that question, which I think would still be my answer to that question, is first, race, because it's always race. And second, privacy, because we don't any longer understand what privacy means in a digital world. That those are the big issues that the society and the court are going to grapple with. And then I used to say the two things that I thought would change during my lifetime were same-sex marriage and capital punishment. I was hopeful. Obviously, the law on same-sex marriage changed. I was hopeful that the Supreme Court was moving towards abolition of the death penalty. That no longer seems very likely, at least in the near term, given who's on the court. Right. But thank you, guys. I really appreciate your taking your time out to participate in this. The questions were terrific. And I know the Supreme Court is somewhat arcane and distant from people's lives, but what it does truly matters and is important. And at the very least, there needs to be public accountability when we think they do the wrong thing. They don't get a pass just because they're the Supreme Court.
Well, we want to thank you very much. I think we'd all agree that was marvelous. So terrific job, everybody.
All right. Well, thank you. And, just stay engaged and stay involved. The greatest sin is apathy, and your, participation in this organization and in calls like this, demonstrate that you may have other sins, but that's not one of them. And I think it's really, it's easy these days to get discouraged. I have to say, I feel that. But, we don't have the luxury of giving in to that discouragement, I think, or, it's many people in our generation, both see reasons for optimism and the activism of young people, and, a willingness to defer to the young. And I think the first is certainly true. I think there is reason for optimism in the activism of young people, but I think that doesn't mean that any of us should retire from the public stage either. I think we all have a lot to add, and we should continue to do that.
One thing's certain, we're living in exciting times.
As you know, may you be cursed to live in interesting times, right? As the Chinese say. All right. Thank you, guys. Thank you very much. It was a real pleasure. Thank you, Joe. See you
Thank you very
soon.
much.
Okay.
Okay, folks, unless somebody has something, some remarks that they want to make, I guess we'll wrap it up and close it for the night. Is there anybody who wants to make a comment? Okay, hearing none, Lee, go ahead.
I was going to say good night.
Oh, good night. That's a good comment. Hearing none other than Lee saying good night, I'm looking for the little button that ends things. And good night, all.